I rise to speak on the Justice Legislation Amendment, Fines, Reform and Other Matters Bill 2022. This is the second Justice Bill we have discussed in as many weeks, which can only be a good thing given the state of our justice system. As we learned through the recent inquiry into Victoria's criminal justice system, the system is multifaceted. While fines were not directly discussed, I know from experience volunteering at a community legal centre that they make up a large proportion of criminal work and cases before the courts. So it is very important that we see bills like this to try and get the system working as it should. This bill seeks to implement numerous recommendations of the Fines Reform Advisory Board, which was established in 2019 after a scathing Ombudsman report into Fines Victoria and fines reform in this state. Fines reform was initiated by the previous Liberal Nationals government when we secured passage of the Fines Reform Act 2014. The Labor government then delayed that bill coming into operation until 2018, and Victorians have been the ones who felt the impact of those delays. The fine system was described as a monumental disaster by my predecessor, the Honourable Edward O'Donoghue, and I think that sums it up perfectly. We have seen hundreds of Victorians have their licences wrongfully suspended, and we have seen Fines Victoria send enforcement letters to people who have passed away despite having received a death certificate. Victorians have had their jobs impacted because of how fines reform was handled by the Andrews Labor government. There was a taxi driver who went without wages for a month while his licence was suspended, only for Fines Victoria to later backflip and accept he did not commit the traffic offence he was fined for. There were fines sent to households despite the agency being repetitively asked to not send them there due to family violence risks. Given one of the main reasons for the fines reform was to make things easier for vulnerable Victorians, it is appalling that the system got itself into such a debacle and that it ended up making it worse for vulnerable Victorians. These were just some of more than 600 complaints made to the Ombudsman about Fines Victoria. The system is broken and it has failed Victorians, so this bill is not something the opposition will be opposing. This bill inserts a number of objectives into the Fines Reform Act 2014, which was a recommendation from the Fines Reform Advisory Board. It also makes amendments to the Infringements Act 2006 to reflect those recommendations. This bill will change the time served provisions for prisoners. As it currently stands, the ability for prisoners to convert fines into time served differ depending on whether the fines are court-issued or infringement fines. This new provision will harmonise the rules so that those applying to infringement fines will apply to all fines. It should clear up any confusion about what fines can count as time served and make things less complicated for all involved in our criminal justice system. This should also reduce the disastrous backlog we see in the Magistrates' Court, as it will enable more fines to be resolved administratively through the time served scheme. The time served scheme is important as it allows people who have exited prison the opportunity to resolve their fines and move forward post-release, without their fines holding them back or putting them at risk of future arrest if they get to final stages. The bill requires the Attorney-General to prepare and produce an annual report regarding infringements and the exercise of the internal review oversight function by the Director of Fines Victoria. The report will be published on the Department of Justice and Community Safety website. This has come about because Fines Victoria do not have any capacity to undertake merits reviews of fines. It is essentially an administrative collection agency because the power to review fines sits with the organisation that issued them, whether it be a local council, Victoria Police or a tolling company. The Director of Fines Victoria oversees these internal reviews and will provide an annual report, which is a good thing because this system is clearly flawed and requires adequate oversight. Just last sitting I spoke on the Justice Legislation Amendment Trial by Judge Alone and Others Matters Bill 2022 and raised my concerns over the severe backlog in our courts at the moment. We have the worst criminal case backlog in the country in the Magistrates' Court, which is where the majority of the smaller fines matters are heard. In that backlogged list would be people waiting for their day in court to contest fines wrongly issued or to explain their reasonings. If we can get the fine system working as it should, with only appropriate fines being issued and proper review mechanisms in place, it should go some way towards reducing these cases in the future. The bill also responds to a finding by the Ombudsman that some local councils were outsourcing their internal reviews to third-party agencies. I would have thought that the best place for a fine to be reviewed is by the very agency that issued it, not some third party. This bill legislates reviews cannot be outsourced. Thousands of Victorians were hit with hefty fines during COVID-19 lockdowns, regardless of their situation. The Andrews Labor government took a one-size-fits-all approach to handling out extraordinary fines, and only about 6% of the 11,362 COVID-related fines issued last year were paid. I am told figures were not much better in 2020. The public health rules were in place to stop the spread of the virus. But was the size of these fines really proportionate? I ask that question. The ABC recently told the story of a 25-year-old mother who was fined for leaving home without a valid reason during the 2020 lockdown. English was this woman's second language, so she struggled to keep up with the ever-changing restrictions and rules. She suffered from family violence, had a history of depression, had missed mental health appointments and was struggling with her children, who were restless after being cooped up for months on end. She decided to take the kids to stay with the extended family, but the neighbours tipped off police and she was fined $1,652. Police said she did not have a valid reason to be out. 2 years later, the fine still hangs over her head. This woman needed a break, but sadly, discretion did not exist. It is cases like these that are clogging up our community legal centres and worsening the backlog in our criminal justice system. These fines are disproportionate and can be crippling for Victorians from low socio-economic backgrounds. As I said previously, fines reform was meant to provide better options for vulnerable Victorians issued with fines. We have that purpose on one hand, and then on the other, we have the Andrews Labor government creating disproportionate fines. The 2021 figures show areas with higher rates of disadvantage accumulated some of the most fines. The areas of Casey, Hume and Brimbank topped the list of council areas with the most. If this government is serious about fines reform, it can't be handing out disproportionate, excessive fines. The excessive COVID fines have only added to Victorians' hardship and added to court backlogs. While we are on the topic of court matters, I wish to outline some concerns that the community legal sector have expressed over these reforms. These issues were raised by my colleagues in the other place, as they require some clarity, but we are yet to receive answers from the government. The first issue the sector have raised is around the withdrawal of infringement notices by toll operators. This bill will allow tolling companies such as Eastlink and CityLink to request an enforcement agency to withdraw an infringement notice. This means that the toll company can request Victoria Police to withdraw infringement notices in respect of unpaid tolls. It makes sense that an agency with the power to issue fines is also able to withdraw them. This comes directly from Recommendation 20 of the Fines Reform Advisory Board. The issue and solution identified by the board was to amend the CityLink Act, the Eastlink Act, and other relevant acts to provide toll operators power to withdraw tolling infringement fines if they wanted to do so. But this bill leaves Victoria Police the discretion as to whether they will withdraw a fine in accordance with the toll operator's wishes or not. The explanatory memorandum says the amendment preserves the discretion of the enforcement agency to withdraw an infringement notice. If the police did not issue the fine, why do they need discretion as to whether they will proceed with the fine? This is a question for the government, and so far they have failed to answer it. There may be good reason for it, but at the moment it is not clear. The community legal sector makes a great point. It is the toll operator's infringement, and if they no longer want to pursue it, why do Victoria Police have discretion to proceed with it regardless? I think that's a fair question that should be answered by the government for the sake of clarity. There are two other issues the community legal sector have raised. The first is Section 22 of the Fines Reform Act 2014. This section lists circumstances in which a fine can be withdrawn. At the moment, fines can't be withdrawn under this section if a 7-day notice and warrant has been issued. The sector have questioned why this hasn't been amended to allow fines to be withdrawn after the 7-day notice has been issued. The last issue they have raised is the stage in which the withdrawal requests can be effected. They believe this bill will be more effective if withdrawal requests can include the time after an infringement has been registered with Fines Victoria. The community legal sector deal with Victorians impacted by the fine system every day, and they raise some great points about how we can improve this bill. There's a few amendments that are floating around. The Greens did put forward an amendment that was issued last Friday. However, we will not be supporting that amendment. Equality before the law is a fundamental aspect of our legal system. Their amendment to reduce fines by 80% for people on a government payment or allowance does not reflect the principle of equality before the law. Transport Matters have also flagged some amendments. However, we believe that these are reasonable amendments and will be supporting them. Overall, this bill implements 5 recommendations from the Fines Review Advisory Board. There are still a number of recommendations to be considered by the government, and we would like to see them implemented as soon as possible to address the mishaps of Victoria's fine system. Looking forward to the next few sitting weeks, we will soon be discussing the Road Safety Legislation Amendment Bill 2022. This bill will add to the list of serious offences that Victoria Police may use to trigger immediate licence suspensions and disqualification, and also seeks to allow for new camera technology to receive evidentiary status. Before we look at introducing new fines and offences, we need to get the fine system right. That is the only way we can stop adding to court backlogs. Victorians deserve a proper system. I encourage the government to get on with implementing the rest of the recommendations.